a time when the United States of America is grappling with abortion rights, a landmark judgment has come from the Supreme Court of India on abortion rights. The court recently allowed an unmarried woman whose relationship status had changed during her pregnancy to terminate her 24-week fetus, saying that being unmarried should not affect her right to terminate her pregnancy. Now, what did the court exactly say in this ruling and how will it affect women? I will explain to you in this episode of KYC, or Know Your Constitution. So in this case, basically the petitioner was a 25-year-old woman. She's a permanent resident of Manipur but is currently living in Delhi. So she first approached the Delhi High Court saying that while the pregnancy was a result of a consensual relationship, she wanted to terminate it because her partner had refused to marry her. She also told the court that she feared stigmatization in the society as a single unmarried woman who is now pregnant. But the Delhi High Court rejected her request, and during oral observations, the judges even went on to coax the woman to carry her pregnancy to term and to give up the newborn for adoption. It even said things like, and I quote, "We will not permit you to kill the child." So challenging this decision, she then went on to the Supreme Court. Now, let me first tell you a bit about the law in India and what does it exactly say. So, abortions in India are regulated by the Medical Termination of Pregnancy Act 1971. This law, as it currently stands, so it was amended recently. Right now, it allows termination of pregnancy for all women in the first 20 weeks on the opinion of a registered medical practitioner. However, only certain categories of women are allowed termination after these 20 weeks. So between 20 and 24 weeks, only certain categories of women can be permitted to terminate their pregnancies, and that too under certain special circumstances. And what are these special circumstances? Basically, Rule 3B of the Medical Termination of Pregnancy Rules 2003 lists down 7 categories of women who are eligible for termination of their pregnancies between 20 and 24 weeks. You can see the complete list of categories on your screen, but for this case, I want you to focus on one of these categories, which is women who have a change of marital status during the ongoing pregnancy, and in brackets it says widowhood or divorce. So now you see the options here mention a married woman whose marital status changes during an ongoing pregnancy because of widowhood or divorce, but does not mention an unmarried woman. But this is exactly the gap in law that the Supreme Court felt that the current petitioner falls in. Now, let me explain how. Basically, the Supreme Court noted that the 1971 Act was amended in 2021, and one of the provisions that this amendment changed was an explanation to Section 3, Subclause 2 of the Act. Before this amendment, this explanation talked about a situation in which a pregnancy occurs because of any failure of, say, any contraceptive used by a married woman or her husband. This was amended in 2021 to talk instead about contraception used by any woman or her partner. So while this provision itself, Section 3 Subclause 2, is not relevant to the case at hand because it does not pertain to pregnancies between 20 to 24 weeks, the court used this provision for an interpretation. It used it to show that the 2021 amendment wanted to include unmarried women and single women within the law too. So it's a bit complicated, but what the court basically wanted to show is that the law was amended to include married as well as unmarried women under its ambit. So the court then said that it in fact called Rule 3B a gap in law and said that if it can cover divorcees and widows, it can also cover an unmarried woman whose partner deserted her during her pregnancy, and that's exactly what happened in this case. So the court emphasized on the fact that the petitioner should not be denied the benefit of terminating her pregnancy and benefit of the law just because she's unmarried. It also said that she had approached the Delhi High Court before she was 24 weeks pregnant, and so delay in judicial process cannot work against her. Now, while talking about these rights, the court also emphasized on a woman's right to reproductive choice and asserted that it is an inseparable part of her personal liberty under Article 21 of the Constitution. And it cited several court judgments which have ruled this, like the Puttaswamy judgment on right to privacy. The court said that this judgment had said that the decision of a woman to have a child or to not have a child is also an important aspect of her right to lead a life with dignity and her right to privacy under Article 21 of the Constitution. So what the court directed in this case is that it requested the director of the All India Institute of Medical Sciences, which is AIIMS in Delhi, to constitute a medical board to examine the petitioner. Why was this done? It's because for pregnancies between 20 to 24 weeks old, the opinion of two doctors is required. They have to determine, and I quote, if the continuance of the pregnancy would involve a risk to the life of the pregnant woman or a grave injury to her physical or mental health, unquote, or it needs to see if there's any substantial risk that if the child was born, the child would suffer from any physical or mental abnormalities as to be seriously handicapped. So this medical board has to determine this before agreeing to terminate the woman's pregnancy. So now in this case, if this medical board concludes that the fetus can be aborted without any danger to the life of the petitioner, then a team of AIIMS doctor will carry out the abortion. So in totality, what this decision does is that it expands the law to include unmarried women also in its ambit. And this would of course allow more women to access healthcare services without going to the court for it every time. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.